You think this is on? You think we're okay? I'm gonna go first.
Oh, yeah.
Welcome, everyone. Welcome everyone again to New Orleans. We are very excited about how our program has been going. I do want to say a couple words of thanks. First, I want to acknowledge the Armenian Bar Association board members who have traveled here. And that is with the Honorable Judge Armenui Ashvanyan, who is in the LA Superior Court. Armen Hovanesian, a past chair of the association, and Levon Golenduchen, who is the mastermind behind he's a symposium planner extraordinaire. And so we're very grateful that the Armenia Programs Committee of the Armenian Bar has undertaken this series, and this is the second in the series, and so we were thrilled to be able to come here for that. There's two other people that we have to say thank you to. Actually, first let me also acknowledge and thank our sponsors who contributed financially to the success of this program. And in particular, I want to thank Phil Kanayan, who came from Houston. And Professor Onik Dombalagian, who will be here in a little bit, as well as our other usual sponsors. So we're very grateful for your support of this. As I said in the morning, this could not have happened were it not for Professor Patrick Hug, who really took his curiosity and concern about the people of Artsakh, I think, is what brought us here. And so we have a little something for you. And Armen wrote it, so you know it's good. But he said I had to read it, which is hit and miss. It says, "Dear Professor Hug, you reside and are rooted in the rare, less traveled intersection of universal truths, overarching empathy, and the embrace of the, quote, other as if your own. On the occasion of the seminal symposium on the inalienable rights of the people and state of Artsakh, we say simply, thank you. Because of you, that less traveled road is now illuminated." From the Armenian Bar Association. Please come up so we can take a photo.
Beautiful. That's beautiful. Thank you. And thank you, Armen. That's great.
Thank you. This book is by Matthew Karanyan, who is a lawyer by training, and he has been documenting the various regions of Armenia and historic Armenia over the past, I don't know how many years.
Thank you. Thank you.
The other person we have to thank is, of course, Jack Ponton, who is the editor-in-chief of this journal. And I don't know how or why or what force made him take this on, but he did, and he's been a terrific person to work with. He has a team. We've met many of them over Zoom. It's been a pleasure to get to know each of you, and I really hope that some or all of you have found inspiration, maybe in not this particular conflict, but in the injustices that happen around the world everywhere, and that you will use the legal training in your profession to look out for the rights of people who are often not heard. And this being a good example of that. And this also Armen wrote, but I will read. And it says, "Dear Jack, though you are a student of law and learning, You have taught us even more valuable lessons about life and legacy. For both to matter most, they must have that special set of values, ethics plus principles, that you have: compassion, curiosity, and conviction. You bring hope and vitality to the inspirational and somewhat still aspirational motto of the United States: E pluribus unum, out of many, we are one. So this is for you. Thank you.
Thank you so much.
Okay, and with that, I hand it over to you.
Thank you all very much. My name is Jack Ponton. I'm currently serving as the editor-in-chief of the Journal of Public Interest Law here at Loyola. When I got an email from a professor who I hadn't met yet, Professor Hug, in August, I hardly thought that I would see myself here, about 7 months later, getting to meet some incredible people throughout the process, leaning on my team and some of my really good friends who have been supportive and helpful and communicative through this entire planning process. Thank you so much to the Bar Association, Levon, Lucy, who I contact when it's 8 a.m. here and it's 6 a.m. in Los Angeles. I don't realize it until after I sent the email. But everybody who was just willing to help from start to finish. And I'm really proud of the way that this turned out. And we've had 2 incredible panels. I'm excited for the last one. Last night at the cocktail party at Professor Hug's house, we spoke a little bit about awareness. And I don't think that you can really tackle any issue or begin to consider solutions until you have a group that's aware. Armin used the old mantra, if a tree falls in the forest and nobody's around to hear it, it doesn't make a sound. But unfortunately, if human rights violations take place and nobody's aware of them, they still happen. So just the idea that we can come to New Orleans and have an entire discussion about human rights issues, in the region of Armenia, and just a place that, I'm from here. I had no idea this was going on, and it's so important, and there's so many things and tragedies like this taking place across the world. And so, it's been a real privilege and an honor to get to learn, and I've learned so much today and throughout this process. And hopefully we can take this and work towards a solution. And I know that, once all these papers get published and, the Journal of Public Interest Law at Loyola New Orleans will have an entire edition about this crisis. And I think that's unique to academia and law school, and so I'm proud of it, and I'm excited for what's to come. And thank you all so much for letting me step in and be a part of this. So without further ado, I'd like to introduce our keynote speaker, Professor Leah Calabro, who we've worked very close with planning this entire event. She's been fantastic. I met her for the first time today in person, but there have been many a Zoom call. Professor Calabro is the visiting associate professor and fellow for the International and Comparative Law program. She is a graduate with honors of GW Law with a concentration in international and comparative law. During her time at GW Law, Professor Calabro was a Thurgood Marshall Scholar, an executive articles editor for the George Washington International Law Review, and a member of the Philip C. Jessup International Law Moot Court team and recipient of the Judge Albert H. Grenadier Award. She worked as a student attorney for the Global Network Initiative as part of the International Human Rights Clinic. in addition to working as a research assistant for Professors Sean Murphy and Edward Swain. Professor Calabro is also an alumna of the GW Oxford International Human Rights Law Program. And prior to returning to GW, she served as a law clerk on the Special Matters Unit Fraud Division for CACI International Incorporated. Professor Calabro holds a JD from the George Washington University Law School and both a BA and a BFA from the University of Massachusetts Amherst. Please welcome our keynote speaker, Professor Leah Calabro.
Thank you so much for that introduction, Jack. I am going to also follow up with several thanks before I get into the actual substantive part of my speech today. So first, I want to extend my deepest gratitude to all of the wonderful people who are involved in the planning of today's events. Lucy, Levin, Professor Hug, Jack, all of the other students on the Journal of Public Interest Law. Thank you so much for getting this group together today. It has been so far wonderful, and I hope it continues to be just as great. Also, thank you to the Armenian Bar Association for their support in organizing this symposium. Thank you to our wonderful authors who have presented such great work today and who are going to no doubt write really incredible articles to contribute to this scholarship. And then of course, thank you to Loyola for hosting us, and to all of you for attending today and being so engaged with this subject matter. Now to get into it, I will say it's been nice following the first two panels and also what Jack just said about awareness. I think that's going to be seen as kind of a through line throughout today, and it's also going to remain part of the main point of what I'm about to say today. So it's heartening to see so many people interested and invested in the important issue that brings us together today, and that's the protection of human rights in unrecognized and partially recognized states. This issue demonstrates the repercussions from a historical perspective of years of war and displacement, changing borders, and the arbitrary demarcation of state lines. We have sadly seen the importance of this topic on display in recent years as we witness the fallout of these recurrent failures to guarantee the right to self-determination to people around the world. The conversation surrounding the protection of human rights in unrecognized and partially recognized states demonstrate a broader void in international law, and that is the clear shortcomings of the current international legal regime to successfully protect human rights in general. We live in a world inundated by ethnic, religious, and political tensions, violence and conflict, and a general lack of respect for the international legal norms that the international community has spent so long developing. We are also faced by unprecedented challenges such as climate change that threaten to vastly alter the global landscape and in turn change our current understanding of human rights obligations and protections in the years to come. According to scholar and professor Ingrid Brunk, we are living in a post-human rights era, meaning that we have transitioned out of what Louis Henkin called the age of rights. In other words, the decades immediately following World War II, during which there was incredible momentum behind creating an international legal order to codify, protect, and even expand human rights, is seemingly behind us. This transition can be seen in the rise in populism in recent years, the progressive contempt for the international rule of law on several fronts, and the increasing disregard of the legitimacy of international bodies. All of this, of course, leads us to the current events of today, from the ongoing conflicts all around the world in Gaza, Ukraine, Sudan, Ethiopia. The list continues. We see the coups happening in Haiti right now. We see the events that we are here to talk about in Nagorno-Karabakh. We also see the regression of human rights protections in states like the United States, which had seemingly been beyond that. So recognizing that we may now be in this post-human rights era does not mean that the protection of human rights is no longer important or obligatory. Rather, it feels that we are at an opportune moment to analyze the current state and the future of human rights protections in this new era, and perhaps this time will shed a light on an underutilized and maybe more effective mechanisms for the protection of human rights across the globe, including in unrecognized and partially recognized states. When discussing the protection of rights from an international legal standpoint, the obligation to protect is normatively understood to fall on states. Each state is expected to abide by both its treaty obligations and its customary international law obligations by ensuring the protections of rights enshrined in those bodies of law. The question remains, how do we ensure that states follow through on these obligations? And of course, how do we ensure protection when there is no per se state claiming these obligations? Well, at the interstate level, we see states imposing sanctions and applying political pressure. We also have seen an increase in the use of the International Court of Justice in an attempt to maintain the international legal order. The ICJ has never been as busy as it is right now, with 20 cases currently on its docket. We see Ukraine bringing the Russian Federation before the court with allegations of genocide, and South Africa bringing the same allegations before the court against Israel. There have also been requests for advisory opinions related to the Israeli practices affecting the human rights of the Palestinian people, and also states' obligations related to climate change. And related to all of these, we are also seeing requests for provisional measures and provisional measures being announced. Yet, we still have not necessarily seen the true impact of these decisions. There are a lot of critics who argue that the ICJ lacks real enforcement power, and therefore it can only achieve so much. This is a common criticism of international bodies in general, and even of international law. And while I am not among the skeptics of these systems and believe in their importance, and I'm very glad to see states attempting to hold each other to account through these mechanisms, it does beg the question, what else can be done? What are our other avenues to ensure protection of human rights, particularly in these gray areas of statehood? It's important here to note before I get any further that although the focus of today is on the protection of human rights specifically, human rights do not exist in a vacuum. The protection of these rights cannot be guaranteed or understood without the broader international legal system. State respect for the international rule of law indicates whether or not they will abide by their international legal obligations, including under international humanitarian law, international human rights law, all of which are incredibly interrelated and have a direct impact on the experience of individuals. International criminal law specifically has been described by Ambassador Beth Van Schaack and Professor Ronald Sly as, quote, encompassing parts of both international humanitarian law and international human rights law, but transcending both, end quote. And I'm glad to be directly following David's presentation because he did an excellent job kind of explaining the more broad functioning of international criminal law, and that is exactly what I'm going to be focusing on today. So this brings me to the importance of international criminal law and specifically individual accountability in the protection of human rights. The purpose in my remarks today is to analyze the effectiveness of international criminal law and individual accountability, particularly in the form of universal jurisdiction, at protecting human rights through deterrence at a global scale, which would apply regardless of the status of state recognition. The push for individual accountability for atrocity crimes in particular is, relatively speaking, a more recent phenomenon. Although the Nuremberg and Tokyo tribunals following World War II are considered to be the conception of modern-day international criminal law, the next phase of development in this area of law came with the ad hoc mixed and special tribunals of the late 90s to present day, and of the International Criminal Court as it began its mandate in 2002, all of which were and are dedicated to the prosecution and accountability of individuals for heinous crimes and to hopefully achieve the end of impunity. We also see this desire to end impunity in the recent surge in several states' use of universal jurisdiction. What was once conceived of as an avenue to jurisdiction for crimes such as piracy and the slave trade, given that those crimes had no fixed geographic location and transcended national boundaries, is now being used to prosecute individuals for international crimes stemming from violations of international human rights law and international humanitarian law. Universal jurisdiction allows domestic courts in any country to properly exercise jurisdiction to prosecute certain egregious international crimes, regardless of where the events took place, regardless of the nationality of the perpetrator, and regardless of the nationality of the victims. This form of jurisdiction is based on the recognition by international law that certain crimes are so serious that the duty to prosecute them transcends all borders, and that people who commit crimes such as crimes against humanity, genocide, and war crimes are, quote, enemies of all mankind. In recent years, we have seen states use their universal jurisdiction laws to successfully prosecute individuals who are guilty of these atrocities. Germany, for instance, which has had a universal jurisdiction statute in place since 2002 and has used this jurisdiction to prosecute and convict several former Islamic State members for crimes committed against the Yazidi people. In November 2021, the Higher Regional Court in Frankfurt convicted Taha al-Jamali of genocide, crimes against humanity resulting in death, war crimes, aiding and abetting war crimes, and bodily harm resulting in death. This case marked the first time that a person had been found guilty of genocide for the mistreatment of the Yazidi people. Germany continues to use its universal jurisdiction laws to prosecute numerous crimes committed in Syria and Iraq, as well as crimes committed in the Gambia, Rwanda, the Democratic Republic of Congo, and other places. Other countries are also increasingly using their universal jurisdiction laws. I believe Argentina was mentioned during the last panel, and they are perhaps one of the greatest proponents of universal jurisdiction. Early on, they used universal jurisdiction to try individuals from the Franco regime in Spain for crimes against humanity. More recently, in August of 2022, lawyers acting for the Uyghur Human Rights Project and the World Uyghur Congress filed a criminal complaint in Buenos Aires for genocide and crimes against humanity committed against the Uyghurs and other Turkic China. They submitted evidence of genocide, crimes against humanity, and torture. Unfortunately, in August of 2023, the prosecutor made a decision to stay the case given a mistake. They were under the mistaken belief that a case was moving forward in Turkey. However, the victims appealed this decision, and the appeals court heard their appeal this past December. So hopefully in the next coming weeks or months, we'll hear a decision on that, and hopefully they will re-prosecute this case. An Argentine court has also heard testimony in June of last year in a case against Myanmar military officials, civilian leadership, and even former presidents of Myanmar regarding crimes against humanity and genocide being committed against the Rohingya people. Argentina is also actively investigating crimes taking place in Venezuela under its universal jurisdiction laws. So we see the broad spectrum of the capabilities of this area, of this avenue to jurisdiction. Aside from Germany and Argentina, we see France recently expanding its restrictive sense of universal jurisdiction. Switzerland opened a trial in January of 2024 for serious crimes committed in the Gambia by Gambian Interior Minister Ousmane Sonko, who is charged with crimes against humanity relating to torture, kidnapping, sexual violence, and unlawful killings between 2000 and 2016. Spain, the UK, Sweden, Belgium, Senegal, Canada, and many other countries actively use their universal jurisdiction statutes. Now, to backtrack just a little bit, the International Criminal Court is not the focus today for several reasons, but most importantly, because of its very limited reach. The ICC, as we learned in the last panel, only has jurisdiction in 4 constrained instances: when crimes are committed by in the territory of a state party, when the perpetrator is a state party national, when a non-party state submits to specific jurisdiction, and when the Security Council refers the situation to the Office of the Prosecutor using their Chapter 7 powers. The jurisdiction over the crime of aggression is restricted even further. That functions in its own entirely different way. I will not get into that. That takes up a 2-hour class just in and of itself. And there is the possibility for Security Council deferral of investigations and prosecutions, which could result in the pause of these ongoing attempts at justice. The ICC did envision, however, that through its functioning, it would put an end to impunity for the perpetrators of these crimes and thus contribute to the prevention of such crimes. We can see how many states saw the potential for prosecutions of their citizens and potentially of their government officials as threatening in the negotiation history of the Rome Statute. The convention that we have today is not nearly as broad as it had been intended to be at the start of negotiations. It's much more restrictive because they had to consistently make compromises and to kind of narrow the jurisdictional capabilities of the court in order to gain state support. In fact, one of the main reasons that the United States has yet to become a party to the Rome Statute is due to concerns with the ICC having jurisdiction over US citizens and officials. Clearly, the ICC's existence and its ability to prosecute, if it can obtain jurisdiction, does serve as a deterrence. As I stated before, the ICC has extremely limited reach, and we are unfortunately living in a time where respect for international bodies such as the ICC is waning. Although we see the ICC gaining jurisdiction in places like Armenia and issuing new arrest warrants related to Ukraine just this past week. It is actively engaged in what is happening in the world today. It does not seem that its existence in and of itself is sufficient to achieve that prevention through deterrence that it aspires for. Hopefully one day it will, but for the time being, it is likely more effective for it to contribute to this deterrence in conjunction with universal jurisdiction. Universal jurisdiction laws, depending on the state, can allow for much broader grants of jurisdiction than the ICC. To tie this back to the more general protection of human rights, we can look to the crime against humanity of persecution as an example. At the ICC, this crime is defined in Article 7.1h of the Rome Statute, which describes persecution as being an act against any identifiable group or collectivity on political, racial, national, ethnic, cultural, religious, gender, or other grounds that are universally recognized as impermissible under international law in connection with any act referred to in this paragraph or any crime within the jurisdiction of the court. I want to draw especially close attention to the last aspect of this definition, in connection with any act referred to in this paragraph or any crime within the jurisdiction of the court. Although the Rome Statute enumerates of crimes, this required connection actually deviates from how previous tribunals have handled the crime of persecution. At both the International Criminal Tribunal for the former Yugoslavia and the International Criminal Tribunal for Rwanda, there was no such requirement for there to be a connection between an act of persecution that could be charged as a crime against humanity and any other crime listed in the respective statutes of those tribunals. In fact, at the ICTY, we see the trial chamber in the Kopreskic case saying that the actus reus of persecution under Article 5H of that statute is the gross or blatant denial on discriminatory grounds of a fundamental right laid down in international customary or treaty law, reaching the same level of gravity as the other acts prohibited in Article 5 of the statute. The mens rea of persecution obviously remained that requisite discriminatory motivation, but what we can take away from what we see the ICTY laying out in this case is that persecution can consist of the deprivation of a wide variety of rights. It can take diverse forms, and it does not necessarily require a physical element. The key constituent of persecution appears to be the carrying out of any prohibited conduct directed against the civilian population, which is a requirement of any crime against humanity, and motivated by a discriminatory animus. The ICC diverged from this during the negotiations of the Rome Statute in an effort to compromise in order to gain more states to be on board with the convention. Therefore, just because the language in the Rome Statute requires the persecutory act to have a connection to another crime in the statute, this does not preclude states from enacting domestic jurisdiction that would expand the scope of their prosecutorial reach under universal jurisdiction for this crime, particularly given the fact that we have precedent coming from the ICTY and ICTR that the connection has not always been an element of this crime. Therefore, we could see universal jurisdiction prosecutions of the crime of persecution specifically as a very effective mechanism for protecting human rights in states where either the state itself is failing to abide by its obligations to protect, or where, as in the case of unrecognized and partially recognized states, it's unclear what entity is responsible and how to hold them accountable. To close the loop on this, I say that the use of universal jurisdiction prosecutions would be effective at holding states accountable for and hopefully at preventing and deterring human rights violations because they would present a similar pressure to that which the ICC provides. Because states do, in fact, see the possibility of external prosecutions of their citizens and particularly of their high-level government officials as something to avoid, regardless of if this is by the ICC or another state's domestic courts. There are, of course, criticisms of universal jurisdiction, such as the concerns related to complementarity, state sovereignty, defendants' rights in the cases of in absentia prosecutions, and on the flip side of that, the feasibility of these prosecutions when there's a requirement of the accused to be in the territory of the prosecuting state. There have been and continue to be discussions before the United Nations Sixth Committee to come up with a principle on the scope and application of universal jurisdiction, and there's potential that the outcome of these conversations could minimize some of the concerns put forth by the aforementioned criticisms by creating a more uniform understanding of the application of universal jurisdiction. However, this remains to be seen as these conversations are still ongoing, but that is something to be watching hopefully in the near future. That being said, there's one concern regarding universal jurisdiction that I want to discuss more in depth and that is the lack of connection with the victimized community given the remote nature of these prosecutions. It is critical that when having these conversations about ways to fill this void in international law and how to shore up protections of human rights, we must involve those most impacted by these violations. We are currently in a moment in which mass human rights violations and international crimes are taking place all around the world. So it is important to figure out a way to repair the damage that has been done while also thinking of how to provide more successful protections moving forward. From a transitional justice standpoint, in order for a community to move past a period of commission of mass human rights violations and international crimes, it is those who are most affected by these atrocities who have to regain trust in the institutions that allowed them to happen in the first place. Therefore, it is the survivors and the victimized communities that need to dictate how best to move on from these events. This could mean granting amnesty, establishing a truth commission, requiring a public apology, memorialization, or those more traditional routes of civil or criminal trials. Communities can also seek guarantees of non-repetition from states and perpetrators who fail to abide by these obligations to protect. It is important for these communities to participate in the design and implementation of these pathways so that they achieve what the community envisions as the best way forward. And depending on what the goals and desires of each community are, universal jurisdiction can in many circumstances help them achieve those. Of note is the fact that many of the universal jurisdiction cases that I mentioned earlier actually were initiated or at least heavily involved victims and survivors and groups that were representative of these interests. Looking to the German prosecution of Taha al-Jamali as a specific example, just to give some brief background on that situation, so Taha al-Jamali had purchased a mother and daughter from a Yazidi slave market, and following months of torture, he chose to leave the daughter in the hot sun for hours as a form of punishment for wetting the bed. This unfortunately resulted in her death. And so the mother of this girl was extremely involved in the prosecution of this individual who had done such terrible things to both her and her daughter. And she worked closely with Amal Clooney, who has served as an extremely important part of legal teams in the German universal jurisdiction prosecutions related to Iraq and Syria. Many other survivors testified in this trial as well. And spokespeople from the legal team and from survivor groups were very outspoken about the fact that they saw this as a major win and a big step towards finding justice for their community. But they also stated that it was only a first step and needed to be followed by subsequent and many other prosecutions in order for them to actually achieve that sense of justice that they had been seeking for so long. The case of al-Jamali has also served as an illustration of a very liberal application of universal jurisdiction, as it was the first case using universal jurisdiction to try someone who is not a German citizen and who was arrested in another country, namely Greece, and only extradited to Germany on the basis of an international arrest warrant. That is the first time that we actually see that happening, and again, it really demonstrates what can be achieved when international cooperation and universal jurisdiction come together. Even in circumstances like that of the al-Jamali case and the other cases I mentioned in which survivors do play an important role in the prosecutions, it remains that the prosecutions taking place in countries hundreds to thousands of miles away from where the actual events took place may still be viewed as incredibly distant by the impacted communities and may not create the same sense of justice as addressing the issue locally would. Oftentimes, outreach can be a great solution to this issue. Looking again to the Yazidi community as an example, there are many NGOs actively working on justice for the survivors, and they are very involved with the communities back in Iraq, as well as the communities who exist abroad, to ensure that they are kept informed about the ongoing cases and have the ability to take part if they wish. All in all, the increased use of universal jurisdiction can, at first, achieve the justice goals and desires of the survivors of these violations and their communities. And in doing so, they set an example of how these prosecutions can be used to hold violators and perpetrators to account. And that example, in turn, can achieve a level of prevention and deterrence of international crimes and violations of both international human rights law and international humanitarian law that we have yet to achieve. In order to accomplish the increased use of universal jurisdiction, however, this requires a willingness on the parts of states to pursue these prosecutions, and this will not happen without public support, which brings me to my final point. This is something that I tell my students every semester, and that is that building public awareness and support is half the battle. We can look to the United States' approach to genocide determinations and formal recognition of genocides as an example of the power of public opinion. There is no actual policy guiding US government officials on when and how to make genocide determinations, but it is very clear that there is a correlation between these recognitions and US public opinion. There have only ever been 8 genocide determinations in the history of the US, including Rwanda, Myanmar, and finally, recently, Armenia, made by the US government. And at the time of the determinations, it's very clear that there was popular support for each of them. There's a reason why it took 100 years for the US to declare that the genocide in Armenia was genocide, because it took that long for public support. You cannot remove the politics, unfortunately, out of these determinations and out of really just generally human rights and international law in general. As citizens with a vested interest in human rights and in the lack of protections we are seeing for these rights all around the world right now, we need to engage in conversations and more versions of grassroots activism to help build that public awareness and support to make a difference. It is so important to continue to educate ourselves on these matters, particularly as attorneys and law students with the capacity to more deeply engage with international law, so that we are able to speak knowledgeably and accurately about these issues as we advocate for change. I sincerely hope that each of you feel empowered and inspired by the discussions taking place today to continue the dialogue and carry these ideas beyond the confines of this symposium. Thank you so much. I'm happy to take questions if anyone, has any. Awesome. Well, thank you.
If there are none now.
He's asking to stand. With universal jurisdiction, and we live in a very polarized world, do you see that, if we increase the viability of these universal jurisdiction cases, that we might have politically polarized competing based on political ideology or viewpoint?
Yeah, that's definitely a concern, and that comes with the complementarity criticism and concern is how do we ensure that these are legitimate prosecutions and that they are abiding by international law and that we're not preventing a state with potentially more close ties from exercising its jurisdiction. And I think a lot of that is going to come down to just kind of seeing how it plays out, unfortunately, because we have not seen circumstances in which that, like we saw Argentina deferring to Turkey in the case of the Uyghur case, which ended up not being true, but that could be just kind of a state practice that then becomes custom, in which there is just this understanding that we defer to different states on different cases. But unfortunately, we don't know how it's going to play out, so that is going to take time. Yeah.
Building on that question and that answer, actually, it occurred to me that it's what Argentina did sounds a lot like what U.S. courts do in terms of the doctrine of forum nonconvenience, which is when a more appropriate forum, not necessarily more exclusive, but more
Right.
appropriate forum exists to hear a case, they will defer to there, and it bears on the party applying to move the case to establish the existence of that forum. But that's a creature of kind of English common law, and many European jurisdictions have a more rules-based list pendants doctrine that kind of says we won't touch it if someone else is already on it, regardless of whether we believe we're the more appropriate forum. And especially given the universal jurisdiction practice is so much more popular or practiced in
Yeah.
civil law jurisdictions, is there a potential for tension there, and how can we sort of build on an idea of sort of more comedy and form non-convenience, thoughtfulness
Right.
to
Yeah.
maybe overcome that hurdle?
So I'm very optimistic about what's happening at the UN 6 committee. I do hope that we see this principle being drafted and published and agreed upon by states that kind of provides guidelines for how things should happen when it comes to universal jurisdiction. And I'm optimistic that that would create, not necessarily an enforcing treaty or guideline, but some type of practice that would allow states to navigate those situations better. In the meantime, it is just going to kind of continue acting as, I hate to say this, but a free-for-all. Like, it is kind of first come, first serve, whoever has, and for instance, in the situation of Taha al-Jamali, if Greece had decided that they wanted to prosecute him, Germany wouldn't have any recourse to say, no, you have to extradite him. So there's just going to be contentions, and we could see these things coming before the ICJ. There could be like previous extradition treaties that exist between states that they could claim, even though the litigation with you, and we could see all this play out. But because this is it's not a new theory of jurisdiction by any means, but it is increasingly being used. I think we're going to see these situations very, very soon in the future. Yeah. Great. Awesome. Well, thank you all so much.
Okay, this concludes our luncheon.